Okay, hello, this is Patty Joe. I know I'm still working on audio. I need to save some money and get myself a new interface. So until then, I'm doing the best I can with what I have. I am covering a different issue right now. I know the sound on the first one may have been an issue. We're going to continue on to the second part of it because, again, I know very little about this case. I will review briefly what I did learn from the last one. This is a gentleman by the name of Elijah McClain, I believe is pronounced, who was life was taken in 2019. Um, I don't know what the situation was originally. I know that there are some police officers and paramedics being held accountable. Um, And what I learned from this video, which is from Law and Crime Trial Network, um, is that they've separated out these trials for the people they're holding accountable. Um, and this is verdict watch for the paramedics, which is separate and after the police. I don't know what the case was in that. I haven't dug into that yet. But so far, there was an incident. Police were involved with this young man who was only 23 years old. And there was some sort of altercation, and perhaps, I don't know what the accusations were there, but when suppression, which is the apparently the Aurora Fire Department, which may or may not have had a medic unit, but the medic unit being used on this particular incident was Falk, which is a private. Sometimes private ambulances assist fire departments or the that section of first responders. So that was the hierarchy and situation here. Whether the ambulance comes from the fire department and is a fire department affiliated ambulance, or whether it is coming from a private and is AMR or Falk or whatever company is providing the assistance, suppression is usually there first. It's because they're available more readily than the ambulances. Usually ambulances are running back to back. They are, in the case of privates, they may be doing non-emergent and emergent calls. I don't know how that works. You know, a lot of times the companies will split and have units just for the emergent calls that are waiting for them, but they're all running back to back too. There are not enough in any jurisdiction that I've ever worked with, um, not enough medic units available for per capita. It's just, that's the way it is. So suppression gets there first, and during the snippet of the trial that I saw, which was from the captain, and again, I've already forgotten how to pronounce this gentleman's last name. They were asking for Jeremy Cooper and this other Captain Peter Chichuniak. Sorry if I'm butchering it, I'm learning it. They were going to be asking for the narcotics. I did slightly cover how we chemically restrain people if that's necessary. I don't know whether it was necessary or called for in this case. We would be looking back on it. I'm sure for whatever reason they're thinking and wanting to prepare for that. Chemically restraining somebody is a serious consideration. You have to take in accounts of, you may have to use the medication before you're able to get a full set of vital signs because of whatever it is that's causing the patient not to be able to be cooperative. Sometimes it's a medical reason, sometimes it's drugs or alcohol, sometimes it's a mental issue. But at, that would be the reason you would be chemically restrained. Physical restraints and chemical restraints are often used together because for safety of the patient is the first priority. I'm going to take a listen. Hopefully my YouTube one will be a little bit better. For me, it's alarmingly loud, so I'm going to do my best.
Good to see you guys. Good to be here. Catherine, you weren't here last.
We are picking it up where they're going to start talking about the police section of it, I believe.
Last Friday, it was. I just stormed off. I didn't even stick around, so I'm not sure what happened. But thank you for making your Friday appearance here today. And Jeff, always good to have you. Let me start with you, Jeff. In part of this testimony, we heard the phrase, an officer, quote, body slammed the decedent to the ground. I mean, is that necessary? Is it inflammatory? Is it designed to, kind of heighten the jury's concern for what happened that day?
It's part and parcel for what we're seeing from the defense in all of these Elijah McClain cases. As we know, the judge in her infinite wisdom early on in the prosecution of this death decided to sever all of these cases. And it doesn't happen a lot out here in Colorado. This is my home. I grew up in Aurora. Elijah McClain died in my city. So I'm going to continue to say his name. And this doesn't happen in Colorado. They don't allow co-defendants to point the finger at each other from different trials with different juries very often out here. It's a pretty high standard. I've requested severance of charges of co-defendants more times than I can count. Never once had it granted, but I never represented a bunch of cops who killed a guy. So they allowed this jury to basically listen to the cops point the finger at each other by having separate trials, 2 cops in one trial, a 3rd cop in another, and now they're letting the paramedics do the same thing. And
okay, so it sounds like what I'm learning now is that there's 5 people being held accountable for the death of Elijah McClain. 3 of them are officers, 2 of them are paramedics. I believe we will confirm that they are, who worked for the fire department, and Falk, according to the one person who was testifying, was the ambulance service or the private service that was providing the ambulance transport and care to the hospital. So let's see how this unfolds and see where we go, see what we can learn.
This is exactly what they're all doing, is they're pointing the finger at each other, saying everything was fine on my end. It was that guy who's the problem. And instead of letting the jury hear the totality of the circumstances and have to judge all 5 of these men together, they're letting this circus happen. And it's
sounds like a legal dumpster fire.
Disgusting to watch.
It is. I'll ask you a follow-up on that. Stand by here, Catherine. Why do you think this happened? In your practice there, you don't see it often. You've asked for it, didn't get it. What's the deal? What's going on here?
Cops. It's the system protecting the system. It's exactly what it is. They have 3 cops and 2 paramedics charged. They are fighting against the social justice movement in this country that is actually having people held accountable for their actions when they're in positions of power like this. And this was a senseless, needless death that would not even have been prosecuted. Hear that again. Would not even have been prosecuted by this DA's office if it wasn't for the social justice movement in the summer of 2020. This is a death that predates the social justice movement in this country. And there were so many phone calls to the Adams County District Attorney's Office that when I would call there to talk to a DA, it would tell me if I had something to say about Elijah McClain. It gave me a different phone number. And eventually they had to send it to a grand jury.
Okay, so according to this little snippet here that it's on screen, it said victim was declared dead days after ketamine injection sent him into cardiac arrest. So there was some sort of physical restraint. The chemical restraint of ketamine was used, which came into favor around that time. We used to use things like midazolam, Haldol, which is about as good as grapefruit juice, um, in my opinion. I've never seen it work effectively for what an EMS provider would do. I'm going to go back to Art's article here, where he said that the implication that that you somehow walk up upon a patient who requires this type of restraint, chemical or physical, and you can just simply go down the list that the book says by confirming these things and then and not physically restraining them to try to put the needle in their arm and safely have a sharp out for them. I mean, there were some people that I simply wouldn't do it because they were, it was not safe to have a sharp object around them. So I mean, you have to really consider risks and benefits of this. So I don't know what exactly happened, why the decision. I know that they were considering the decision for chemical restraints. As a medic, I have heard suppression calling me and saying, we're going to request your narcotics, or chemical restraints may be required while I'm on my way. So I'm already thinking about weights, doses, protocols, what I'm going to look for, if I agree with them or not. Just put another set of eyes on it. I don't automatically go by what they say, but I definitely have a lot of confidence in what they say.
And jury indicted all 5 of these gentlemen as co-defendants, and the judge allowed them to sever the trial and run this defense. It is gross. It is causing acquittals where it otherwise wouldn't. Ooh. And it is not the norm in Colorado. They are being treated differently. They are being treated special.
Well, and it has. And Catherine, I want to listen to the cross first, and I'm going to come back to you to talk about the varying outcomes in these severed cases. Let's go now to the cross-examination of this defendant.
You indicated that you were the one who went over and ordered up the ketamine from the Falk ambulance. Is that correct?
That is correct, yes.
You ordered that ketamine in a dosage of 500 milligrams.
Correct, 500.
500, that's...
Prior to doing that, you and Mr. Cooper didn't have a conversation about how much Mr. McClain weighed.
Okay. I'm just... He already gave away what I was going to say. Ketamine is generally a weight-based dose medication. So you have to know the number of kilograms, not the number of pounds, but the number of kilograms. And then we're given a certain weight-based and concentration for pain control, and a certain concentration and weight base for chemical restraints. And it would be a higher concentration, so we're using less because we're generally putting it in a muscle because we probably don't have an IV. So you have to consider, if you are considering, especially if you have time like this, like they appear to, you consider how much does the patient weigh, what would be the appropriate dose, what is our protocol for it, and making sure that the medic on the transport unit agrees with the paramedics on scene.
We had a conversation on the dose.
Right. And you both just agreed 500.
Yes.
But under your estimate of Mr. McClain's weight, the appropriate dose would have only been 425.
Correct.
The reason you moved it up to 500 is because you thought he was extra agitated.
Oh.
I moved it up to 500 because of the training we were given on ketamine, when we were taught to give either 300 for small, 400 for medium, and 500 for large. So I went off the training that we were given.
Now, Mr. Chikuniak, one of the reasons you went up from 425 to 500 is because you thought he had a particularly agitated state and was showing signs and symptoms of excited delirium.
That is correct. And I'm not going to under-medicate someone by giving them 400. I'm going to go.
Excited delirium is a controversial differential diagnosis. We don't call it a diagnosis in the field. We call it a differential diagnosis. And the difference being is we don't really know. That would, excited delirium is, I think it's out of favor now. I don't really know if it's in favor or out of favor, but it implies that there was a substance on board or something that was causing a physical problem in that patient, making them require the chemical sedation. And some of those symptoms include hyperthermia and a lot of different things that can be included that are physical findings, and that I'm going to wonder whether or not that they can document.
Go up to the next one per our training.
Now, in your training, there's nothing in there that says give more if you think they have strong symptoms.
Right. There's nothing printed in the PowerPoint, but those were, as we all heard Mr. Chambers talk about, that he builds off of that, and there's side conversations that go off of that. And that's where we were trained to go 300, 400, 500.
I'm not asking about those starting points of 3, 4, 5. I'm asking about whether or not there is anything in the training that says increase the dose if you think somebody's extra agitated. That's not in there, is it?
Not written in there, no.
You could probably make a very weak argument that if a second dose is required, then, did you give a strong enough dose? But ketamine is a weight-based medication. In other words, however big you are is how much you get. Now, we don't have scales in the ambulance. They don't have scales on the sidewalk. Thank God. And really what he's referring to is medic math. And you know how there's girl math and dog math and this math, and there is a certain extent of medic math. You have to look at a person, and they're either small, medium, or large people, and then you estimate the kilograms based on that. So somebody small may be 50 kilograms, somebody medium maybe 100 kilograms. That's a little bit over 200 pounds. So let's say they're a little less than 200 pounds. Then you would go somewhere between the 50 and 100 and split the difference there and estimate the weight. So you estimate the weight based on the size of the patient. And what this attorney is trying to get at is you estimated it really at 425, but you said 500 just because you thought he was an extra big problem. You wanted to make sure you did it. And this guy's just about getting ready to say, yeah, we wanted to make sure we were dosing him good and solid. Ugh.
And that's not part of one of those side conversations either.
That training was back in 2018, so I couldn't recall every side conversation.
Right. So you have no memory of a side conversation that would say, increase the dose if you think they're extra agitated.
No, I do not.
So if you increased the dose because he was extra agitated, that would not be consistent with your training.
Repeat, I'm sorry. Let me clarify so I can make sure I answer it.
If you increase the dose because of his agitation level, that would be inconsistent with your training.
I disagree.
Didn't you just testify that the training doesn't say that you increase the dose if somebody is extra agitated?
Right.
And you have no memory of any other training side conversation that would say that's okay.
Not for the extra agitation, as you call it.
Right.
Well, remember, the wrinkle we have here that's different from, let's say, George Floyd, is you have the EMTs involved, and they are defendants in this part of the case. Catherine Lizardo is here, Jeffrey Wolf. So, Catherine, I'm looking back, trying to keep straight all the different cases that Jeff says were improperly severed here, and we have one cop tried separately. We have two cops tried together. When the two were tried together, and that was Jason Rosenblatt and Randy Rodema, one comes out guilty, one comes out not guilty, and is fully acquitted. How do you figure that? I mean, obviously, it's very fact-specific, who did more than the other might have done, but it kind of refutes Jeff's concern that by pointing fingers at one another, even in that one trial, it would, slop over from one defendant to the other, and it didn't when you had two totally different outcomes for these guys.
It was very surprising to have two different outcomes in the same trial. Rodema was found guilty, but for a lesser count of criminal negligence and assault instead of the manslaughter that he was charged with. And he was the one that was on top of McClain and had a lot more physical interaction with McClain. I believe maybe that's why the jury found him guilty of the lesser charge compared to the other defendant, the other police officer. But being in the same trial, yes, they were still pointing at each other. And we see here, even with the paramedics, that they too were pointing at each other, even though they were both at the same trial. Whether or not they were severed or together, that was their defense strategy and it worked for them. But I agree with Jeff that it doesn't make sense to sever all five of them, in those different kinds of the way they were organized. I don't even know why certain people were tried separately or together, but for judicial economy and for the jury here.
As we continue to cover this case, guys, I want to break down, who testified, who did not, and what that impact might have been, and see if we can glean anything from that, because both EMTs did testify, as you know. We're looking at one of them right now.
Keeps calling them EMTs. He's correct and incorrect. The old term is we were all EMTs, and there were different levels, and one was paramedic. The new term is EMTs are EMT basics, and then there's advanced EMT, and then there's paramedics. Paramedics are trained to a much higher level and are trained to give these medications. And as we can hear from the testimony of this, he's the captain, as far as I understand. I could be wrong, but his understanding of the medication is, from what he said at that point, fairly rudimentary. I want to hear more from him. I'd rather hear more from him.
Let's take a break. We will come back, talk more about this case again. We are in verdict watch in this Colorado case.
But this commentator is absolutely wrong in his terminology.
Here we go.
And ignorant in it. Right back. Okay. All right. Since he'll be right back, I'm going to leave it there and for this one, and we will see where we're going. Hopefully, my sound is improving a little bit, and you can hear the YouTube, and you can hear me. I know you can hear some of my background noise. I try to make it as quiet as possible, but thank you very much. Like and subscribe. It helps me, and hopefully be able to solve my sound problem soon.